Hey everybody, so I wanted to make a quick video here to update some of the material that's changed because of recent Supreme Court rulings, particularly over three civil liberties areas. The religion clause of the Establishment Clause of religion, the Second Amendment's right to bear arms provision, and then, of course, abortion overturning Roe. So what I figured I'd do here is just show you some of my slides, show you how I'm changing it, because these things are really radically changed in a very short period of time. And this means that all of our textbooks are now out of date, at least as the time I'm recording this, before the beginning of the fall 2022 semester. So starting with the religious clause, the Establishment Clause, what I would normally do is I'd say, okay, let's start with the Establishment Clause. The court had developed this test in Lemon versus Kurtzman. I have the students read a very short summary from oea.org. It just looks like a paragraph. It just goes through the facts, the legal question, and the ruling. And I have them read that summary, and then I would go through with more detail in the subsequent slides about how Lemon works. And then I would, after that, talk about the Free Exercise Clause, which has not changed. I'm sorry, the Free Exercise Clause, which has not changed. So beginning with Lemon, then, I also start them off with this note, but as of 2022, Lemon is definitely dead. I still like to keep it around, however, and go through the basics of Lemon and talk about the Lemon test, which is now gone, right? Because we could say, look, this is what we had, and this is how we're now transitioning. And also for them, it's not really a lot of reading since it's just a paragraph anyway. They're not really wasting a lot of time. So I go through this, I give them more information than what the website I provide them, that OEA website gives them, and I tell them more about the programs at Lemon, and then this is where the update comes in. And say, okay, now that we've done that, let's see what happened in this interim period, right? Why did this change? And so I talk about how starting in 2019, we knew that the court was really starting to move away from this because Trump had started adding more and more conservative justices to the court. And so we saw the development of basically three camps dealing with Lemon. We had some that were in favor of keeping it, although they only made up a small number, about one or two of the members of the court. There were some that wanted to have sort of a modified version where they would apply what they called a reasonable observer standard, looking at if a reasonable observer would say they thought that that was a government endorsement of religion. Others wanted a case-by-case approach. And then finally, there was a few that wanted to completely abolish Lemon, but they didn't really have a clear replacement for what would go there. So as I mentioned, in 2019, we saw this American Legion versus American Humanist Society Association, case come up. This dealt with a giant cross that was located in the median of a highway. And then the American Legion originally owned it, but then they said we can't maintain it because it's just massive. And so we're going to donate this World War I memorial cross to the city. So the city now has possession of this giant cross. And the question was, is this considered, religious endorsement? Is this an establishment of religion violation? And the court said no, but they ignored Lemon completely. And they said instead we should look at, in this American Legion case, historical practices. Those should dictate us. So this seemed to apply like a case-by-case approach. Similarly, a few years, I think either 1 year after that, I think was the year, in a city called Town of Greece versus Galloway, they reaffirmed that it was not a constitutional violation to have a non-denominational prayer before legislative meetings. And so this seemed, again, they did not rely on Lemon to reach these conclusions. And so finally what we get is now we arrive in the modern time, right, in 2022, and that's this Bremerton case. So in this case, as most of you might have seen in the news, it involved this coach, high school coach, and then after the games were over, he would go to the center of the football field and pray, and he was often joined by students. And so what the coach tried to say is, look, either by my free speech rights or by my free exercise rights, I should have the ability to do this after the game, since this is not like a prayer before a high school game or faculty-led prayer or prayer at graduations. This is something I'm doing in my private capacity after my official school duties have ended. If students want to join me, that's fine. And so this increasingly became a spectacle. So instead of it just being a private silent prayer, where maybe some students would rush in, people were rushing the field, right? And there was like a state legislator that showed up and joined him, and the media was there, and it was hardly anything than a private prayer. And so what the other side said is, look, this could be a problem because you have coercion potential, right? You have the peer pressure of, what if I don't pray with the coach? Am I going to be the next student benched? This is tantamount to religious endorsement, right, by the state via the coach's duties. The court, however, said no. In a 6-3, they said that we are completely abandoning Lemon. And instead, what they develop here, as it says, is a new test. And this is what you're going to see is that this new test that they're establishing is basically the same for this case, for the gun rights case, and for abortion. And that is, we're going to look at history and historical traditions as the founding fathers, as we interpret it, thought it meant. This is originalism, right? They're taking originalism and trying to map it onto as many of these constitutional cases as they can, now that the conservative majority constitutes a 6-3. And so what they said was that if we have to draw a line between what is permissible and impermissible, we have to look at it has to be in accord, these regulations, with the history, and has to faithfully reflect the understanding of the founding fathers, and that's directly from the opinion. And so what they're trying to do is increasingly enshrine originalism of what they understand the founding fathers thought was acceptable and not. And so what they said here is that our understanding of this is how we then should confront cases dealing with the Establishment Clause. That's how we will solve these future cases. That's the new test. Lemon is gone. This is now the replacement. Next, turning to the Second Amendment. So here is not such a major change per se, as much as it is a change to the way that we're going to look at how they will approach state and federal regulations dealing with firearms. So as all of you know by now, way back in 2008, the court took up the first major gun rights case they heard in decades, almost a century really, and it dealt with whether or not Washington, D.C. could effectively restrict access to guns. It was almost an outright ban. You had to get permission from I believe it was the chief of police in order to carry a firearm if you weren't a police officer, and they basically never handed these things out. So the question here was, what does the Second Amendment mean? Because it has this really weird language about a well-regulated militia in the front bit, and then it has this other bit about necessary of a people, the security of a free state to keep and bear arms shall not be infringed. So if it has these two clauses, which of these should prevail? In a 5-4 decision, the liberals said, we think both of these clauses work in conjunction, the preface and what they call the operative clause, the bit about the right of the people. These things work together. So the well-regulated militia are the people that keep and bear arms. However, the majority, the conservative majority, said, no, that whole front bit, that prefatory clause, is basically meaningless. It's like an example or an illustration. The real bit's the operative clause. And so this raises the question, well, how then do we determine what sort of arms could be restricted? Right? Should it be only those that were in use at the time by militias in the 1790s, or should it be something else when the Second Amendment was ratified? And so they don't really give us a clear answer, but they say that it has to conform to adapting understanding. So they gave us sort of vague language about what is in modern usage at the time. Right? And so moving forward, just a couple years later, they then took up McDonald versus Chicago, where Chicago basically banned handguns within its city limits. They said, nope, selective incorporation. The Second Amendment now applies to the states as well. But we still didn't really have a clear definition of what the legal standard should be for when the state or the federal government can or can't regulate guns. So we had a few other cases in the interim, things like, well, what about tasers? They said, no, bans on tasers aren't allowed because tasers are in common usage at the time. And they had a couple other ones, I think one dealing with like pepper spray, for example. But so it left us with this idea, right? Okay, then things that are not in common usage, so like bazooka or like a machine gun, those things could be outright banned, perhaps. But then things like what about more, like background checks, or what about red trigger laws or something like that, right? Can we have these restrictions? So in 2022, they heard New York State Rifle and Pistol Association versus Bruen. This case dealt with New York trying to make a law that made it illegal to take guns outside of the home without a special permit, and the special permit was very difficult, if not near impossible, to obtain. So what they do here is they give us two things. One, they say that one of the major purposes of the Second Amendment, the thing of the people to keep and bear arms, is self-defense. Even though the words self-defense do not appear anywhere in the Second Amendment, they conclude that that was one of the primary purposes for enacting the Second Amendment in the first place. So, okay, let's assume that that's the case, because you can't really argue with it, right? How then should we determine whether or not a regulation is acceptable, right, using this standard that they established in Heller? And so what they said was, up to this point, there's been sort of a scattershot of approaches by the district and circuit courts. And most of them had adopted this approach. They would say, okay, we're going to look at the history and tradition of the Second Amendment at the time of the founding. Were there comparable regulations at that time? Can we carry those analogies to the modern times, even though the technology is fundamentally different? And then they would engage in what they call a second step, at least that's what the Supreme Court conservative majority said, and that was they would look at either a means to ends test, and that is do the government means of regulation justify the ends it's seeking to obtain? So like restricting access to, let's say, mentally ill people, does that means achieve an end? Or they would apply an intermediate level of scrutiny, where the burden would be on the government would have to show a compelling need, but it could in some circumstances satisfy that, right? They said that's wrong. Instead, you should have stopped at the first step. looking at the historical background of what the founding fathers, as best as you can figure out, meant for the regulation of firearms to be. So what they say is that this is the test, just that one sentence, the first prong of that two-step test. The second bit about means to ends or intermediate scrutiny, none of that should work, right? So instead they say you should ask, quote, whether modern firearm regulations are consistent with the Second Amendment. And to test you have to look at the history and historical understanding of what the people who wrote that, both the history both before and after ratification, and then also, of course, looking forward to when the 14th Amendment was ratified, because that's when it was selectively applied to the states. And they go on to explain that there are two relevant metrics here. One, whether modern and historical regulations impose a comparable burden on the right of armed self-defense, which again is what they say the Second Amendment means. And two, whether that regulatory burden is comparably justified. Right, and so what they're now suggesting is that any time a state wants, or the federal government wants to make a regulation on firearms, if it's challenged in court, it is then up to the people challenging these laws and the people in the state defending these laws to say that, look, here's what history has led us to conclude, and then a judge will determine whether or not that evidence is consistent with the Second Amendment's text and historical understanding. So, for example, in this case, even the majority conceded there were like one or two instances of laws dealing with outright bans of carrying guns in public outside of the home for purposes of self-defense. But they said, well, but the overwhelming majority of evidence suggested that most states did not have prohibitions against carrying guns outside the homes, so we will weigh that difference. Right now, of course, you can think about the critiques here, but I'm not going to go into that. I'm just showing you some of the updated information here. All right, the last one, privacy. Oh, sorry, skip that. There we go. The last thing, of course, is the change in how we approach abortion cases. So the way that I'm going to approach this, given the change, is I'm still going to have my students, I'm going to go over this opening bit about Griswold and the introduction to the notion of privacy, and then I'm going to have my students read over a summary from OEA.org that talks about that has Roe versus Wade. Now, you might be thinking, well, why? Because Roe's overturned. Well, I think the idea there is that these substantive due process rights are still existing for a number of different areas besides abortion. So just because this one is gone doesn't mean that this foundation of substantive due process rights extend to other areas, because they do, right? At least they do so far. So I start off by talking about Griswold versus Connecticut, about how initially the court approached this by looking at whether or not married couples had a right to discuss contraception. And at the time, Connecticut had a law that prohibited this discussion by medical professionals, which is just weird, but that's what they did. And so the court took up whether or not there is a notion of privacy in the Constitution, because privacy does not exist in the Constitution. The word is not found anywhere. So what they initially do in this opening bit in Griswold to say they use this zone of privacy idea. They talk about a penumbra of privacy, and that even though the word privacy isn't in the Constitution, that it's implied through various other amendments, such as the First Amendment, speech guarantees and religion guarantees, Third Amendment against quartering of troops, Fourth Amendment against unreasonable search and seizures, on and on and on. And so they start off with this idea, this zone of privacy idea, and then they later say, well, that we're not going to stick with that as sort of a workable standard because it's too amorphous. And instead what they turn to is something that is in the Constitution, and that is the Due Process Clause of the 14th Amendment. So what they'll do is initially say that this includes a right to married couples to talk about contraception, and then it extends to a myriad of other different rights, such as interracial marriage, the right to marry somebody even though you're in prison, contraception for unmarried couples, the right to reside with relatives, the right to educate your children, the right not to be sterilized, and on and on. So that's not even the whole list. That's just some of the substantive due process rights that are later determined to exist by the Supreme Court. So after that, of course, then they take up the issue of abortion, whether or not this extends to a right of a woman to control her pregnancy. And of course, in Roe versus Wade, they say it does, right? It includes that guarantee. Initially, what they come up with in Roe is the trimester scheme, where they say, look, we're going to determine when in the pregnancy, if we break it up over trimesters, 3 trimesters throughout the pregnancy, when the state can regulate or even proscribe abortion. And so this is their initial attempt, given the modern state of science understanding at the time. They later, of course, say this isn't really a workable standard because this constantly is changing. We know more about pregnancy as science is developed. And so instead, what they say in Planned Parenthood versus Casey's, they take up a number of different regulations out of Pennsylvania that try to regulate access to abortion, and they say we're going to abandon this this notion of a trimester scheme. Instead, what we're going to come up with is what they up until the recent Dobbs decision was we're going to use what they call the undue burden standard, and that is if the state government creates an undue burden in the path of a woman to seek a lawful abortion, that law will be struck down. And so then they also abandoned this trimester scheme, and they said instead we're going to look at fetal viability. If the fetus could survive outside of the womb, up to that point forward, the state can regulate abortion and even prescribe it, as long as there's things like health and life exceptions for the mother. But before that, a woman has a right to access abortion if they want to. This, of course, changes in 2022 when we get to the Dobbs case. So this one was a 6-3 decision, or sort of 5-4, depending on how you look at it, because the Chief Justice didn't agree with overturning Roe, but he did nonetheless join the majority. So it's technically a 6-3. And what we saw here is that the Supreme Court has reversed basically 50 years of precedent. And they said that we think that, much like we saw in the Second Amendment cases and in those First Amendment cases I just mentioned a second ago, they instead are going to move towards what they call the text and history of the Constitution. So the language they use here is that one of originalism. They say that if it's not expressly mentioned in the Constitution, that any such right must have an origin that is, quote, deeply rooted in this nation's history and tradition and implicit in the concept of ordered liberty, meaning what they think the founders meant when they wrote those words. And so what they do is they say we go back through history. As far as we can tell, the majority says, we don't see abortion as a protected right. It's a new invention, and it's one that was created by the Supreme Court in Roe. So if your students are asking, or you're asking, what does this mean practically for abortion? It means that it's thrown back to the state. Since it's not a constitutionally guaranteed right, it's up to the states to define if they want it to be or not. So some states, including Texas, will have taken steps to completely proscribe this practice, right? The abortion completely banned, even in cases of like rape or incest or health of the mother. All those instances are out the door. The legality of those kind of bans will be challenged in court, so we don't know how that's going to pan out, but it seems like the states have that authority. And then other states are going to extend those benefits, but there's no universal guarantee. So we're going to end up with a patchwork of different states choosing different laws. Does this mean, as it says here, that other substantive due process rights are now going to be up for grabs? And so the reason why this comes up is because there's a paragraph in the opinion written by Justice Alito that says, don't worry about that abortion is a unique act, and that this ruling, the Dobbs decision, only concerns the constitutional right to abortion and no other right. And so he expressly mentions a few other rights that are protected under substantive due process, things like privacy, sodomy laws, same-sex marriage. He says those things are not on the table. The issue, of course, is that Justice Thomas, on the other hand, in his concurrence, directly contradicts that. And so he says that, look, all of these things, many of these things involving substantive due process rights, those now should be reconsidered. Maybe there might be another way to guarantee those rights, such as the Privileges or Immunities Clause of the 14th Amendment, but those things do not exist in the Constitution. What's sort of odd about that is in the concurrence, he lists 3 examples. He lists privacy, he lists sodomy laws, he lists same-sex marriage. One thing that was kind of oddly missing from that, interracial marriage wasn't on there, but that is also a substantive due process case, right? And so you're raising, even though the majority here is saying, look, don't worry about it, these things are not in doubt, this is also the same 6 judges who, when before the Senate Judiciary Committee, said that Roe was settled precedent, or at least some variation of that. So you really have to take that with a grain of salt. And so this means then that the textbook I use also mentions these 2 cases in particular when talking about sodomy and talking about same-sex marriage, and that is that these privacy rights are also extended to these other examples, right? Initially, the court said in Bowers that there is no guarantee to consenting adults to have sodomy as a sexual intercourse. In Lawrence versus Texas, they say substantive due process right. And then, of course, when we get to Burgefell versus Hodges, just not that long ago, we get same-sex marriage, and that's on that same sort of basic understanding, a combination of the Equal Protection Clause and substantive due process. So that's how these things have fundamentally changed. Okay, that's it. I hope this was useful to everyone. If you have any questions about anything, or you want some more details or more feedback, you can always send me an email. It's travis.braidwood@TAMUK.